Hello, good to everyone, and welcome to the Week 5 Moot competition. On behalf of the University of Fiji Organizing Committee, we wish to welcome everyone to our school who is responsible for 2021 Moot competition. Firstly, the judges, for availing ourselves from your busy schedule to be here in today's Moot competition. And secondly, to the Fiji Women's Lawyers Association, thank you for also availing yourselves to be present. And lastly, to the Mooters and to the three institutions, the Fiji National University and the University of the South Pacific and the University of the Fiji. Not only you are here to support your team, but you are also here to witness and experience how a court matter is being performed. So basically, this is something that the law students need to experience, because this Moot competition demonstrates how a legal world works once you graduate from law school. Once again, Malong Bula, and I hope you all enjoy today's Moot. Nah.
Good ceremony. I'd like to call Ms. Kalala Mukalindi for the introduction of our judges for today.
Hi, hello everyone. It's my privilege to introduce our judges this afternoon. Our first judge is, can you guys all hear me? Our first judge, our Chief Judge, sorry. She was admitted into the bar in 2011. She had spent 7 years serving at the Legal Aid Commission. She joined the Legal Aid Commission as a volunteer legal officer. She then progressed through ranks until she reached the post of a principal legal officer. And thereon, she decided to leave and learn more about the human rights. She then, during her time at the Legal Aid Commission, she practiced criminal law, family law, domestic violence law, and some civil matters. She was part of the PILON litigation skill program that was held in Apia, Samoa in 2015. She had also participated in the integration training for the UN High Commissioner for Refugees Pacific Protection Learning Program, which was held in Brisbane, Australia. She joined the Fiji Women's Crisis Center in 2017. She learned about patriarchy, which is the root cause of violence against women and girls in all spheres of society. She is now the Legal Services Manager at the Fiji Women's Crisis Center, and she had stated that she finds a place in feminism as an immensely enjoyable work in the elimination of violence against women and girls. She works at the Crisis Center, which she finds opportunities to undergo consistent gender and human rights training based on international practices, and which is also focuses on the elimination of violence against women. Please welcome our Chief Judge, Ms. Miliana Tarai. She had worked in various roles, including as a volunteer with the Fiji Red Cross, being a hair salon assistant and a student reporter with the FM 96 during her high school days. She worked at Queensland Insurance Limited Claims Department. With regards to her legal profession, she has just over 10 years post-admission experience with practice area in family and criminal law. She was employed for over 6 years with Legal Aid Commission, first as a volunteer legal officer before resigning as a senior legal officer in 2016 to join in private practice. She took a 6 months break from work to work on a farm in 2016 before rejoining private practice in 2019 in the employment of Nagor Chambers. Apart from her legal work at the center, she also enjoys advocacy prevention work on gender-based violence and violence against women at the grassroots level through the service community education activities, which includes traveling to the remotest parts of Italy. She was inspired to pursue her postgraduate studies in the area of gender. She enjoys providing legal services to the community pro bono and also loves farming, breeding, and greenery and solitude of the forest where she lives. Please let us welcome Ms. Lavinia Reisua. And finally, our co-judge, she is a litigation lawyer after graduating from our very own university with a gold medal and getting admitted to the bar. She began her legal career as a state counsel at the Fiji Independent Commission Against Corruption, where her role as a prosecutor focused on white-collar crimes. In late 2016, she moved into civil litigation, where she joined Monroe Lees as a solicitor in both commercial and litigation departments. At Monroe Lees, she was able to expand her experience and knowledge base on employment law, constitutional law, contract and commercial law, and civil litigation. Excuse me. She was thereafter able to supplement her experience in 2018 with further studies after she was awarded an Australian Award Scholarship at the University of Melbourne, where she pursued her master's in commercial law and graduated in 2019. After returning to Fiji, she has further pursued her research and litigation passion at the International Union for Conservation of Nature, Fiji Care Insurance Limited, where she was its manager, governance and legal, and Howard's Lawyers as a litigation lawyer. Currently, she is taking a work break from the law and is enjoying her time at home, spent with her 3 cats and her family. She hopes to return full-time to the law or litigation after she completes her home decor projects and after her Netflix binges with her cats. And please let us welcome none other than Ms. Lilian Garcia.
For a thorough introduction. Now, may I ask that you all rise to our feet? In a moment of silence to honor Emeritus Professor Don Patterson of the University of the South Pacific School of Law, who attains a Bachelor of Law, Masters of Law from the Victoria University of Wellington, and Masters of Law from Yale University in the United States of America. May we all take our seats? Before we proceed to this week's Moot program, we will have the delivery of last week's Moot court program. I'm advised that one of the judges that was present last week will advise the outcome. This is a ruling for round 3 that occurred last week on Friday. This is a ruling on just Ms. Dema, Ms. Pratap, and Ms. Rakai. The date of the hearing took place on Friday, the 26th of March 2021, and judgment is being given. I will not read the entire judgment. Copies will be given out to the parties.
Given that the proceedings filed by the appellant were not against proper parties, I therefore consider not relevant for this court to deal with the ground 3 of the appeal. I therefore order that the appellant's appeal is dismissed for the reasons above and costs to the respondent. Judge Devon has also given some feedback that I'd like to read this afternoon. For the parties that were present at the Moot competition last week, one, both sides were not entirely conversant with a set of facts. There was an apparent confusion between parties on the basic facts as to who made the decision to suspend the scholarship, and this adversely affected each side. For those of you that were present, one party was arguing that it was the government who made the decision, and another party was arguing that it was the board. So that basic fact was confusing for the judge. There was also a lack of reference to the legislation on the governing of the award of the scholarship. So Judge Devon has asked if the students can decipher the facts from the legislation. Also, the cases that were cited were not relevant to the case last week. However, overall, students from both the universities, the University of Fiji National University Students Law Association as the appellant, and the University of Fiji Students Law Association as a respondent, you both did remarkably well in terms of your presentation and delivery. With the assistance of a reporter, can I give copies of the ruling? Is anyone here from FNU, or maybe the secretary can provide? I'll give a copy of the written ruling that's setting out the entire grounds. And your marking sheet will also be given to the secretary for the 2 things to obtain. I will not go over the marking criteria today because I believe you have received the comments last week. All the best for the notice.
Nada. Now I'll call a Moot comment session.
All right. Presiding Justice, the Leadership, Justice Mariana Tarai, the Leadership, Justice Radina Ransoa, and her Leadership, Justice William Mastur. In the photo method between the stage and Johnson. Case number 1 of 2021.
Thank you, Council. I have okay with this.
May it please this honorable court, counsel's name, Wakatu Turanani, first initial S. I am accompanied by my co-counsels, Dinan Indabeta, first initial S, and Ranina, first initial E. We enter in appearance on behalf of the state. Yes, your leadership.
I have the appearances from the respondent.
May it please this honorable court, counsel's name is Harman, first initial C, and I appear with my learned colleague, Sabu, first initial S. And I'm instructing solicitor Nisha, first initial B. Appearing for the respondent, Mr. John Smith, in this matter.
So, for the appellants, have you provided us with case authorities? I have not seen any case authorities in our file. Which is of case authorities? I'm assuming that you will be referring to some case authorities.
Yes, Your Ladyship.
Have you got any bundles for the court?
Yes, Your Ladyship. Family secret to tender the list of authorities in statute that we will be relying on in this.
This must belong to our
And also, if I could seek leave from the court to tender the new submission for our application, I would like to reassure Your Ladyship that the content within our submission has not been changed. We have just altered the format on the basis of minor grammatical errors.
Thank you, Counsel. So, Counsel, how many grounds of appeal are you seeking to advance?
Your Ladyships, we are doing one program.
And are you appealing the conviction, the sentence, both?
Your Ladyships, we are dealing on the grounds that the judge from the lower court had a note on for several grounds.
So this is regarding the conviction or the sentence?
The sentence, yes.
Okay.
The acquittal, Your Ladyship.
And which provision of the Court of Appeal and
We are relying on the section 21, subsection 2, part A of the Court of Appeal Act. We have balance submit an application pursuant to section 21, subsection 2, part A of the Court of Appeal Act, in which that states, the state on a trial held before the High Court may appeal under this part to the Court of Appeal. Part A says, if I may quote, against the acquittal of any person on any ground of appeal which involves a question of law, unquote. Your Ladyships, I will be covering on the first ground of appeal with reference to the Bail Act 2002 on the basis that the learned judge had erred in law in not considering the circumstances in relation to the release of the appellant on bail before the finalization of the matter. And also I will be covering on the second ground of appeal that the judge erred in law in not considering the history of domestic violence suffered by the complainant. My co-counsel will be submitting on the third and the fourth grounds of appeal. If I may proceed with the first ground of appeal, Your Ladyship. If I may direct the court's attention to paragraph 3.0, the first ground of appeal. The learned judge had erred in law in not considering the circumstances in which the release of the accused on bail would affect the complainant, and that the accused's presence when they had resumed cohabitation after being released on bail would affect the complainant in such a way that this would ultimately affect the outcome of the case. Section 22, subsection 1, part B, Your Ladyships, of the Bail Act 2002 stipulates, if I may quote, if bail is granted, bail must be subject to a condition that the accused person must not assault, threaten, or harass the person or persons in respect of whom the alleged offense was committed, unquote. The learned judge had erred in law in not considering the evidence of the complainant being compromised when they had received cohabitation after the respondent was released on bail.
Counsel, now you stated in first round of appeal, 3.1 in paragraph 3.1 that the judge had not considered circumstances in which the release of bail on the accused would affect the complainant. What about the fact that the powers of the court concerning bail was exhausted when the court delivered its bail ruling? This is a great appeal on the acquittal of the respondent. And so, don't you think that the court was factors in regards to bail, so it doesn't, bail doesn't have a bearing on this appeal?
Your ladyship, the finalization of the matter had not reached the decision from the lower court. Hence, we submit in the first round that when the respondents to this case had cohabited with the complainant after the bail, had compromised the evidence of the complainant with regards to the finalization of the matter.
So, is the appellant saying that the court should have revisited the issue of the granting of bail in his judgment? The trial judge should have revisited the issue of the granting of bail?
Yes, your ladyship. The judge, we submit a no, in not considering the circumstances that would occur after the bail had been, after the respondents had been released on bail.
So you're asking, so you're saying that without referring to the circumstances in which bail was granted, isn't that what you're saying? That he did refer to the circumstances of bail at the trial?
Your ladyship, he did not consider the circumstances that would occur after he had made the judgment to release the respondents on bail before the finalization of the matter.
But the court is of the view that bail is a different matter, and bail was not an issue in the trial. Would you agree?
Yes, your ladyship. And also I would like to add that besides from the application of bail, there was also a domestic violence restraining order in place before the matter was heard in the High Court.
And that domestic violence restraining order was in place, was in what conditions were given by the lower court?
The non-molestation order, your ladyship.
So, counsel, don't you agree that with the non-molestation orders, standard non-molestation orders, parties are free to resume cohabitation? There's nothing prohibiting parties from living together?
Your ladyship, I submit that in regards to the domestic violence restraining order, it does not meet the cohabitation or the contact of the two parties.
It's not permitted. That's your argument.
Yes, your ladyship.
Counsel, was this issue of bail, was it raised at the trial stage?
Your ladyship, I believe that we are actually appealing towards this honorable court on the grounds that the judge did not consider during his judgment that had been made in the lower court.
Yes, I understand that, counsel. But my question is, was this issue raised at the lower court? Was this issue raised before the level judge?
Yes, your ladyship, it was. Further to this section, Section 24 Part A of the Bail Act 2002, when an accused person is charged with a domestic violence offence, bail is granted, refused, varied, or discharged by a police officer or by a court. Immediate steps must be taken by the police or by the court, as the case may be, to inform the specially affected person. Unquote. The above provisions clearly outline that the respondent had failed to adhere to his bail conditions by living with the complainant before the finalization of the matter.
Thank you, counsel. I will just stop you there. According to the records that we have, one of the bail conditions that's noted here is that there was supposed to be non-interference by the witness?
You're correct, Your Ladyship.
Is that what you're referring to, in this particular section?
Yes, Your Ladyship. As the respondents have been charged with the domestic violence offense. The learned judge in the lower court failed to consider that this. Yes, Your Ladyship.
I prefer to discuss section 24A of the Bail Act, saying that it was a domestic violence offense and the bail conditions were never. Was this issue brought up in the before the trial court when the matter was heard? Was this issue of bail and the breaching of bail, was it ever raised in evidence in the trial court from the record? Because I don't see anything with regards to the bail conditions in the court record.
Your Ladyship,
Was this matter raised for trial?
Your Ladyships, I am submitting and hence trying to link the consideration of the non-consideration rather of the lower court judge that he did not consider the circumstances. Therefore, within the circumstances, I link the bail issue.
Thank you, counsel. Counsel, are you saying that the trial judge should have considered that cohabitation had been resumed after bail was granted, and that had some bearing on the evidence with the complainant gave in court? Is that what you're
Yes, Your Ladyships. Yes, Your Ladyships.
and that gave him the opportunity to influence the complainant?
Yes, Your Ladyship.
But was there any evidence that there was left before the lower court that there was actually interference that had compromised the evidence given by the complainant?
Your Ladyships, after the respondent had been released on bail, they continued cohabitation with the complainant. Therefore, contrary to the statements that had been collected from the complainant, she submitted that she would always take the blame. She would also submit to her husband. She would also confess that she was a good wife, and she would never, in a statement, blame the respondent.
But what we are trying to ascertain is whether there was any evidence to that effect that the respondent in this matter had actually interfered with the complainant, in the sense that there was any evidence about compromisation of her evidence. Though she had mentioned that,
Yes, Your Ladyship.
but was there any evidence in fact to say that there was evidence was actually compromised because of that qualification that had resumed after bail was granted?
Your Ladyship, I think that this was clearly observed during the trial in the lower court, that the lower judge, the lower high court judge, had derived his judgment not from the law, but from the statements that were being said by the complainant. The learned judge, if I may proceed, Your Ladyship. The learned judge in the lower court failed to consider that this breach of bail conditions by the respondent will lead to the evidence of the complainant being compromised, which was clearly observed during the trial. If I may direct the court's attention to Section 24 Part 8 of the Bail Act 2002, pursuant to this section, it was the duty of the court and the police officer to ensure that the accused does not make further contact with the complainant after the accused is released on bail. Therefore, the learned judge had erred in law in not considering these circumstances.
So, isn't it on the record that it was the complainant's decision to move back with the respondent, her husband? So the issue of interference is not there.
something?
Yes, Your Ladyship. Contrary to her interviews, she had also mentioned that she would always submit to her husband and that she would always take the blame. Hence, we are submitting that there had been some form of influence to the complainant by the respondent that had led her to giving the statements that she had said.
So what you're saying, counsel, is that the statements which she had used in her evidence, those statements you have just mentioned, those imply, they do not actually say or give rise that there was interference by the accused person with the complainant to change her statement.
Yes, Your Ladyship. If I may proceed with the second round of appeal.
So the court would have inferred that there was interference.
Yes, Your Ladyship. With the prosecution witness, who is the complainant.
And the prosecution had raised this in the lower court, that there was interference of any kind?
Your Ladyship, the interference we gather that it had came from when the respondent was released on bail and that he cohabited with the complainant as he was released on bail. We submit that that was the interference because the matter had not been finalized yet in the lower court.
So you want the court to consider that it was a cohabitation alone, the fact of cohabitation alone, or cohabitation in light of the whole evidence of complaint?
Cohabitation in light with the evidence, Your Ladyship. We have to proceed with the second round of appeal. The second round of appeal. The learned judge had heard in law is not considering the history of domestic abuse suffered by the complainant during the period of 31st of December 2019 and to 31st of January 2020. The lower court did not take into consideration that there was a domestic violence restraining order in place. This basically depicts that the complainant in this matter was living in fear. This is an important aspect of the case, Your Ladyships, that was not considered by the learned judge. In accordance with the case of R versus Al-Waliya, 1992, for all England reports, after a period of time the victim had been with her husband, it was concluded that the victim was subjected to domestic violence and assault and years of violence and cruel treatment.
Also, we had a look at R against Al-Waliya.
Yes, Your Ladyships.
Just give us the brief facts about this case, because this is an issue.
Yes, Your Ladyships. Your Ladyships, R versus Al-Waliya case, the partners had lived together. Though they had been living together, the victim in this case had always suffered abuse, assault, and also some form of torment for various, from time to time, I could say. And this was an ongoing thing to a point that the victim could not take the pressure anymore. She decided to wake up, she could not go to sleep that night, therefore she woke up and burned the husband's room in which the husband was sleeping. The partner in your relationships.
Counsel, can you hear me?
Yes, Your Ladyship.
So, Regina and Al-Waliya was a murder case, and
Yes, Your
prohibition
Ladyship.
was,
Was defined in our
and I get the crux of this condition, you have the benefit procedure,
Yes, Your Ladyship.
but I have not seen how it's prosecuted until the second, which makes me never further.
Yes, Your Ladyship. I would like to link the fact that there is relevance in the fact that both the victims of the Al-Wali case and this case had suffered abuse from a long period of time. Therefore, it had some form of threat to the complainant and also in the Al-Wali case.
Yes, counsel, but then for denying Awalia,
Yes, Your Ladyship.
in that particular matter, the lady was she not the accused?
She was the accused, Your Ladyship.
And in the case that you are advancing before this court, in the appeal, the lady is a complainant.
Yes, Your Ladyship.
The charges are totally different from each other.
Yes, Your Ladyship.
So, just make it clear to us the relevance of why you're referring to this particular case. A case in which baby is an accused person.
Your Ladyship, we have referred to the case, relying on that it showed the history of domestic abuse suffered by the victim, which is also evident for this case, in which the victim for this case had suffered also in abuse.
So the set of facts and the circumstances that arose in the provocation in Regina are not
Yes,
completely different from the case at hand. So I think on the basis of law itself, I'm struggling to find a commonality. The murder charge and the rape charge. Because the provocation defense that was pleaded by the accused in Regina and Al-Wala came about after 10 years of involved violence. And their lordships in that case had restrained the principle of law, that is the defense of provocation, to only include a moment to induce control after years and years and years of abuse. And then that control leads to murder. So I would be grateful if you could assist the court in how that could possibly apply in this case.
So what we are asking is what authority or legal principle you want to draw from that case, or any parallel you want to draw with regards to this case.
Your Ladyship, it is the history of domestic violence abuse that has been suffered by both victims. We are submitting that the judge, the law court, had not considered this, had not considered that the complainant had suffered domestic abuse for some period of time in making his judgment during the trial judgment in the law court.
But counsel, in the judgment itself, the alleged trial judge had actually referred to the abuse that was happening. Yes.
Your Ladyship, he might have referred to the history. I may not be able to say that the learned judge had referred to the history, but he had referred to the domestic abuse, but not in the context from which I am submitting the appeal. Hence, we submitted the judge idea.
Are you trying to say, counsel, that the issues, the issue in Al-Walia was provocation, and before in this appeal is the issue of consent, because sexual intercourse is not denied. Are you trying to say that in regards to victims of domestic violence, that they don't react, they're just trying to understand which legal principle you want to apply in this case? Are you trying to say that victims of domestic violence usually don't react in regards to consent or the lack of consent in this appeal?
Your Ladyship, the battered woman syndrome identifies the psychological effects on victims of such form of abuse. Mainly, it differs in context as they are physical, sexual, and also psychological effects that victims have to be subjected to. Therefore, they are not in any capacity to respond. For many reasons, there can be fear. Also, the fact of being alone. So the victims are left in the dark, therefore they are not in any capacity to respond.
When you say respond, Council, what do you mean?
Your Lordship, I was referring to the judge's response to certain scenarios or
In the context of this particular case, are you trying to tell us that respond in the sense that she can give consent?
Your Lordships, the victims may be reluctant to consent and to even show. They end up being silent, therefore they are not able, they may be able to psychologically consent, but that does not show physically because of the abuse that they from time to time encounter.
Is there any case authority apart from Ahluwalia
Yes,
you
Your
would want
Lordships.
to refer to regarding this particular issue of domestic violence and its connection to rape?
Yes, Your Lordships. Our versus Alvaria case had got a principle from the principle that had defined sudden and temporary loss of control in victims who suffer from this abuse in the case of R versus Duffy, 1949, one all in reports. So the principle obtained from this case had shown that that it was evident among those victims that the abuse had resulted from a slow burn reaction, meaning that there had been a series of events, not just one event. It occurred from a span of more than 5, 7, 9 months, and not just immediate.
And in the case before us, the one that you are pleading,
Yes, Your Lordship.
how long were they married?
We were married for a year.
They were married for a year.
Your Lordship, the case before you is the partners are not legally married. They are in a 2-year de facto relationship. If I may clarify that for the court. If I may proceed. The term battered woman syndrome identifies psychological symptoms developed in some women who are victims of physical, sexual, and psychological abuse, making it difficult for them to regain control. This is clearly caused by a history of domestic abuse relating back to the case of R versus Alvalia, 1992. Relative to this case, the complainant had confirmed that the accused would physically assault and berate her daily. 4 things which the accused would say was her fault. Furthermore, police had to intervene with the beatings being inflicted on the complainant. Hence, the judge had erred in law in not considering the history of domestic abuse that the complainant had undergone or gone through. I've now come to the end of my submissions, Your Lordships. If I may now invite my co-counsel, who will be submitting on the third and fourth grounds of appeal.
My ladies, I will be presenting this honorable court, our third and fourth round of our appeal. May May I bring your attention to paragraph 5.0? Your leaderships. The left judge in High Court early judgment, when he used various types of gender stereotype as the basis of his finding as to the complainant's consent. On the stereotype, there is the wife's responsibility to submit to the husband. The apparent submit to the court has not considered the fact that the complainant had not consented to the sexual act, be it verbally or implied. The learned judge has based his judgment on the gender stereotype in regards to the issue of consent, whereas it was also highlighted in the reasoning that submission without physical resistance by the complainant to act of another person shall not alone constitute a consent. With the reference of R versus R 1992 1 All Court 599, where the defendant was charged with attempted rape and assault occasioning actual bodily harm against his wife. His allegations was argued on the grounds of marital rape exception that executed under the common law of England and the principle that a husband is not liable to rape his wife. It was held that there was no marital rape exception under English law, and this was a common law fiction. The concept, absolute consent of a wife to her husband is classed as an unacceptable consent in modern terms. It is seen to be equal partners in a marriage. It went on to say that the relationship between the parties to rape does not matter. Rape is rape. On that note, using stereotype as a basis for establishing the issues of consent should not be used as it contradicts to what is highlighted in R versus R 1992 1 All Court 599, and both parties will be held equals.
Counsel, so I take that your submission on this point is that the marital exception to rape no longer exists. That's what I'm gathering from your submission.
Yes, Your Lordship.
But you have a local case of an RMO.
Absolutely disagree with the case. Proceed with my submission.
Sorry, Counsel, I have a question to ask you.
I understand that your Brown case regarding gender stereotype statement.
Yes.
And you have referred the court to one particular statement that the law commented on, which is the wife's responsibility is to submit to her husband.
Yes, Your Lordship.
Now, apart from this particular sentence that was used in the judgment, was there any other statements that were made that would be, statement of gender stereotype? Right? Because, as I understand it from reading the judgment, it was not just like one sentence that the learned judge had actually based his judgment on. In fact, he had talked about how he had considered the demeanor of the complainant when she was giving evidence, right?
Yes, Your Lordship.
And apart from that, there were other evidence which came out during trial that he had also used. So all in all, it does not really come out from the judgment itself that one statement was the basis of the finding of not guilty. It resulted in the acquittal of the respondent. So I'm not really understanding this particular round of appeal where you just referring to one sentence of gender stereotype. When you have a whole paragraph 20, but I'm just referring to the judgment. Paragraph 20, there were a lot of things that the judge had actually considered to reach his judgment.
I may get into that point of your niche. I may get into that point later.
Sorry,
I
Council.
will get into that point. May I proceed with my submission? Dear leadership, the appellants admit that even though there was no resistance on the part of the same, the giving or refusing of consent should not be assumed. The appellants admitted that on one occasion, the accused has returned home drunk and had sexual intercourse. The respondent did so without asking. The appellant would like to add that she was scared if she said no to the respondent, and he might leave her as that's what he would be telling her every day. The appellant would like to refer the court to the case of R versus Coburn, 1Q.B.217, 1976. Because there was a presence of fear, the complainant was present not to resist. With reference to our case, the same fear is present with the appellant as his already admitted fear of being left alone, and this is a pressure that is on her, and should be taken into account as the reason why the appellant portrayed no resistance.
Council, did the complainant actually said that she had fear when she was giving her evidence? Could you just point me to that particular place in the judge? I'm having trouble finding it.
Pardon me, may I ask the assistant for my co-counsel, get them to the questions.
Very well, Council.
Your leadership, it is fear is not stated in the judgment, but it's a statement by the complainant on page 117. May I proceed with my submission? The appellant would like to submit that if that High Court judge did not consider the fact that the appellant did not express her choice of not giving consent under Section 206 of the Crimes Act 2009. It states, the term consent means consent freely and voluntarily given by the person with the necessary mental capacity to give consent. To express their choice is irrelevant and was considered by the High Court, and it is received under the law, and it does not take that into account. Your Ladyship, due to the fact that the presence of common law authorities establishes equality of the parties, and that the relationship is irrelevant, consent is to be given even though the parties are cohabiting with each other. This does not only rule out the stereotypes that establishes inequality, it also sets out the ground that although it is not expressly stated, consent should be given. In addition to this, even though there was no resistance on part of the appellant, this alone cannot constitute consent as stated under Section 206 of the Crimes Act 2009. Since there was fear present, this should take precedence above all others. It has taken to its toll on the appellant to freely choose and express her ability to give consent, which has been misinterpreted. As the appellant's ability to give consent has been surrendered. Given that the respondent had a sexual intercourse with the appellant on several occasions without asking for her consent, it has given him the assumption that she is consent, or that is a part of being married, that she is to surrender herself to him freely. Therefore,
are you saying that because of the fear, she did not have the necessary mental capacity to give consent?
your medicine, because the fear inflicted in her has no, she has no courage to resist.
But how does that lead to your field run that you're trying to advance, the gender's field run?
That's the question.
How does that particular argument assist you? Because you're trying to argue under this ground about gender stereotype comments that were made, right?
That's correct, Rich.
The gender stereotype comment you have referred to the court was the photo was with regards to submitting to the husband. So am I to understand that what you are trying to say is that that particular statement in terms of what you're referring to Section 206 of the Crimes Act, consent does not necessarily have to be expressed. Is that what you're trying to tell us?
Yes.
And mere submission, that shows lack of consent.
Yes.
Is it also by exercising of authority? So you think that could be it as well?
Yes.
Do you wish to expand on that?
What is the video will be able to elaborate on that first. Maybe.
Do you think the husband comes under the definition of someone who exercises authority over?
Yes. Release.
And how would you like to tie that into the issue of consent? This field in terms of section 209, the legal framework, what rate?
Your Ladyship, contrary to Section 206 of the Crimes Act, if I may refer the court to Part D, by exercise of authority, your question had referred to a husband, or who in this case is the de facto partner of the complainant, as a person of a male gender, the dominant gender. He had exercised authority, and therefore fear was created in the complainant when he was exercising authority. Therefore, there was consent gained from the complainant through the fear.
But wouldn't you say that's mutually canceling? You're saying that there's consent that's given to the fear.
Yes, Your Ladyship.
In the admin of the law itself, you can't get consent if there is fear. That's what section 136.
Yes, Your Ladyship. So, if I may rephrase my statement, the consent was not given, has not been given by the complainant because of fear. And this fear had amounted from the de facto partner exercising his authority over the complainant. Therefore, consent had not been obtained by the complainant. If that is assisted the court.
But the complainant is not the one that's supposed to obtain the consent.
Your Ladyship, we submit that though the complainant had not obtained the consent, neither did the respondent ask.
So the complainant did not give the consent.
Yes, Your Ladyship. Thank you.
And counsel, just before you proceed, now in the judgment, the learned judge actually talked about being a good and beautiful wife. What do you have to say about that particular statement that the learned judge had said?
Because of the gender stereotype that has been repeated by family, that is submitted to the husband as a beautiful and good wife. Thank you. I may draw your attention to paragraph 6.0 for the fourth ground of our appeal. Your Ladyship, the learned judge, in acquitting the accused by finding the prosecution had not proved beyond reasonable doubt the issue of lack of consent when there was evidence that the complainant had not given her consent. Section 206, subsection 1, and subsection 2 of the Crimes Act stipulate that the term consent means consent freely and voluntarily given by the person with the necessary mental capacity to give the consent and the submission without physical assistance by being present to an act of another person shall not alone constitute a consent. Without limiting subsection 1, a person consent to an act is not freely and voluntarily given if it is obtained by force, by threat, or intimidating, or by fear or bodily harm, by exercise of authority, or by force or fraudulent representations about the nature or purpose of the act, or by the mistaken belief induced by the accused person that the accused person was the person's sexual partner. Your Ladyship, the issue of consent is legally defined in the above legislation. The complainant admits that she continued to stay with the accused out of fear. They will fight and continue to live together, though they will not talk to one another. The complainant continued to live with the accused even when he had physically assaulted her for talking to the neighbor. She lived in fear of being a bad wife, as he would physically assault her. She couldn't even bring herself to say no when he would want to have sexual intercourse out of fear. Furthermore, in reference to the case of R versus R 1992, 1 All Court 599, it was held that there was no mental rape exception under the English law, and this was a common law fiction. At the end of the day, rape is rape. Being married is not a consent for a man to have. Let's give confidence about pattern solution.
Sorry, counsel, just say that last line again.
Furthermore, in reference to the case of R versus R 1992, 1 All Court 599, it was held that there was no marital rape exception under English law, and this was a common law fiction. At the end of the day, rape is rape. Being married is not consent for men to have. married is not a consent here. Being married is not consent for men to have sex with his wife.
How have the courts, in your understanding, dealt with the issue of consent in terms of the marriage? Would you have them explicitly ask for consent before every instance?
Yes, we did see.
Was there any evidence that was being led during the lower court trial that points to this issue of consent or the lack of it?
I believe there was none.
There was no evidence.
There was no evidence, but very little of fear of the complainant that itself alone create this could not resist for consent.
And at no point did she ever say no. That was according to the evidence from the lower court.
It is correctly received.
Counsel, does our law require the complainant to expressly say no to the respondent? And was the state required to prove the no?
What do you mean, will you rephrase the question again, please?
Does our law in PG on rape require the complainant to expressly say no to the respondent, the de facto husband? And was the state required to prove that?
No.
Level of consent, the no.
No, we will need to reach.
The law doesn't require that for them to expressly say no.
In light of the discussion alluded above, it is within our prerogative to tell them that this application is considered in this honorable court.
Sorry, Counsel, I'm not clear enough.
I'm sorry. My apologies, my issue.
So what exactly are you asking this court to do?
To reconsider
You are appearing for the appellant in this case, correct?
yes, please.
You are the one that's bringing this case to the Court of Appeal?
For appeal to be granted.
Yes, please.
So you do not wish for the respondent's application to be dismissed to the court? Help me understand, now I'm getting.
Your Ladyship, if I may assist my co-counsel. What my co-counsel was trying to elaborate is that contrary to her ladyship's question, that consent not only can be done voluntarily, contrary to section 206 of the Crimes Act, it can be obtained by force, threat, intimidation, and other forms. And also to your question, your ladyship, that my co-counsel had wanted to submit that this honorable court would consider the third and fourth grounds of appeal, which is that the learned judge in the third ground of appeal, that the learned judge had erred in his judgment when he used various gender stereotypes as the basis of his findings, and also for the fourth ground of appeal to be considered by this court, that the learned judge had erred in acquitting the accused by finding the prosecution had not proven the beyond a reasonable doubt in the issue of consent. So, your ladyship, what my co-counsel had tried to say was that if this honorable court would consider our grounds of appeal this evening. Thank you.
Counsel, so are you saying that if the trial judge
had considered the issues that you are raising now on appeal, the issues on appeal, how would he have arrived at a different outcome?
Your Ladyship, the 4 grounds of appeal that we are appealing to this Honorable Court today, we submit that if the learned judge had considered, if he had considered these grounds, there would have been a change in his judgment and the case would not have been acquitted. So therefore we have appealed before this Honorable Court this evening. Thank you.
We have nothing else to
Council Overflow? Your Lordships, before we commence, the Council would like to seek leave of the court to hand in our copy of submissions and unbundle authorities, as well as to provide other defense with a copy of the same.
the council should know all this should have been provided prior or all this provided.
Your Lordships, before I commence, there is a preliminary application that the Council would like to bring before the court. Firstly, that we extend our deepest apologies for being late to the proceedings today. Secondly, that the case citation for the state against Ismail should read, the state against Ismail in the year 2014, as reported in the High Court Criminal Case Action Number 115 of 2012, that has been amended in the copy of submissions that are currently before you. Also, that submission 4.1.1 should read section 2.7 instead of section 270. That has also been amended in the copy of submissions before you. Also, my ladies, we would like to seek leave of the court to omit submission 3.7 on our copy of submissions, as the council respondents feel that it is not relevant to the case at hand. That is submission 3.7, my ladies. And lastly, we would like to seek leave of the court to advise that we intend to argue and consolidate grounds 1, 2, and 3 of the appeal, with ground 4 being argued separately. I will be addressing grounds 1, 2, and 3, which have been consolidated, and will be speaking for 15 minutes, while my learned colleague will be addressing ground 4 and will be speaking for 15 minutes. In bringing this matter, the orders that we humbly seek are that the acquittal be upheld, that the learned judge do not delay law or fact, and that the appeal be dismissed with cause. If your Lordships have no further questions on that format, the respondent will now like to proceed with the submissions. Your Lordship, as stated, the respondents will be arguing grounds 1, 2, and 3 together. Would your Lordships like me to restate the grounds of appeal, or shall I proceed with the submissions?
No, council, you shall just
Very well, Your Lordship. Your Lordships, our client has denied interfering with the complainant after he was bailed. He has denied coercing her into making her think that it was her fault. The fact that she kept on looking to the accused while giving evidence also does not suggest that the accused had compromised her evidence. Based on the evidence adduced before the court in this instance, there were no physical beatings following the resumption of cohabitation, and there is nothing to suggest that our client had in fact interfered or compromised with her evidence. If my ladyship has no further questions on that form, I would now like to proceed with submission 3.6. Your ladyships, in regards to the evidence, it is apparent that the complainant did not identify herself as a victim of domestic violence or gender stereotyping. It was her belief that she was being a good wife, and it did not become apparent to either the accused or the complainant that it was wrong until after the feminist counseling session. On the occasion in question, the complainant made no express gestures or verbal discontent, and throughout her cross-examination doubted herself. Your ladyships, the reasonable doubt was created by the complainant's evidence alone. The learned judge correctly found in favor of the accused and made no reference to gender stereotypes at all, but was merely quoting the complainant's statements and the evidence adduced before the court. These findings were made only after hearing the evidence before him.
Counsel, I have a question. If you look at paragraph 20 of the judgment, the learned trial judge had actually quoted certain statements in which he had faced peace and said that she had the opportunity to inform her sister and that she was overlooking a good wife, and that she was submitting to her husband when she was being a good wife. Aren't those gender stereotypes statements?
Certainly, your ladyship, they are gender stereotype statements. However, in regards to the case at hand, it is our submission and a submission that we maintain that the learned judge made these findings on the evidence that was before him.
But do you think that was relevant for him to consider? The fact that she was submitting to her husband.
My ladyship, I will talk about that in my further submissions. However, if my lady would like, I could elaborate on that now. Sorry, my ladyship, could you just repeat the specific statement that you are referring to in paragraph 20?
That she did not, she had the opportunity to inform her sister, but she didn't, and that she was being a good wife, but was speaking to her husband.
My lady, I will first address the statement on the good wife. So in regards to the good wife, up until the time that the fifth allegation, when the police had actually interfered, and they had then, when the fifth allegation came up, it was not apparent to neither the accused nor the complainant that there had been, that this was an issue, because that was their belief and that was a normality within their de facto relationship, that she was being a good wife. And it wasn't made apparent to both parties that it was actually wrong until the feminist counseling session.
But did the accused person, the respondent, did he ever ask for her consent?
No, your ladyship, but it's something that we can infer, and it's something that we will be making for our submissions today, that it was something based on a previous occasion, and something that he could reasonably have an honest belief that there was consent.
But Counsel, have you had a look at section 206?
Yes, ma'am.
The risks of a crime act?
Yes, my lady. Which part would you be referring to in section 6?
The 8. It says that you face no need for express consent. So it could be consent has to be free and voluntary received. But in this case, from the judgment, the evidence that has been required, the complainant did not give her consent, nor she ever asked her.
Yes, my lady. If we may refer to paragraph 13, where
Paragraph 31?
of the judgment of the court of this instance. On the facts, it had stated that according to the complainant, her relationship with the accused was good and that they sometimes fight. During these fights, the accused and the complainant would not speak to each other. However, they would continue to carry on as husband and wife, albeit not talking to each other. Carrying on as husband and wife, according to the complainant, would also mean having sexual intercourse. Relationship, that normality and the arrangement between the accused and the complainant was one that was normal according to them, and they did not realize it was wrong until the feminist counseling session. And per the facts, it was actually after the feminist counseling session, after they had realized it was wrong, that the accused had actually ceased his actions.
But also, in paragraph 15 of the judgment, it cited that the complainant herself had mentioned that she did not like the act of sexual intercourse, which she had been subjected to.
Yes, Your Ladyship, that is correct in paragraph 15.
So you have a complainant that did not like those acts. The consent was never asked for. So how would you argue that that is not relevant?
Your Ladyship, we are not arguing that it is not, respectively, we are not arguing that it is not relevant, but rather that she had not made it known at any point in their relationship to the accused that she was in fact uncomfortable, or that she was in fact not consenting, or any other related matters. So there was no way, as the judge had previously mentioned, there was no way for the accused to actually know that she was uncomfortable.
Counsel, from the judgment itself, in evidence, the complainant had stated that she had given evidence of instances of domestic violence. In fact, there was a domestic violence restraining order, and that was admitted by the defense. And I note from your submissions that you say that the complainant herself, she did not identify herself as a victim of domestic violence, but it came out in evidence during trial stage that there was a domestic violence restraining order. And it also came out in evidence that this allegation of rape came into light when the neighbors had reported her husband to the police for having physically assaulted her. She never called the police at all. And you're saying she is not a victim of domestic violence?
Relation, just to clarify, yes, we are maintaining that she did not realize that she was in fact being subjected to things that would be seen as wrong.
So because she was not, she didn't realize herself that she was going through domestic violence, that this court should not consider it?
Certainly not, my lady. The argument that we would like to make is that because she was not aware, and because we would like to draw a comparison from domestic violence to the issue of consent, but because she was not aware, because she was not aware of these things, she was not able to express it to the accused. And we clearly see from the facts that if she had in fact expressed it to the accused, we see what would have happened. And that was after the counseling session when he actually ceased his actions.
Yes, counsel, I know from the judgment that there were fights. She was physically assaulted for talking to a male, threatening to leave her if she refused sex, daily physical assault, berating, blaming her. There were previous complaints to the police, which were reconciled at the police station. He was the sole breadwinner, and it came out also in evidence that they had discussed what happened about the case when he was brought to bail. And she stated that it was her fault, and also the defendant himself, the accused, your client had stated that it was a misunderstanding on their part. How does that not amount to domestic violence?
Your Ladyship, we are certainly not denying that there was no domestic violence. there was. However, the issue in contention is whether or not there was consent or lack thereof, as mentioned by the trial judge. In regards to misunderstanding on her part, it is our understanding that the phrase "on her part" was with reference to her coming forward and expressing her discontent with the accused.
Don't you agree that she was scared into or intimidated into submission because of all this happening?
Well, my lady, if she was, that was not known to our client.
I'm sorry, counsel?
If she was in fact, from the facts, we know that from her cross-examination that she was in fact afraid of the accused by paragraph 17. But however, our client was not aware of this.
But then your client did not ask for permission to have sex with her either. He never asked for her consent.
Yes, Your Ladyship. And we take that as my learned colleagues will subsequently mention, that there was honest and reasonable belief that there had been consent because of similar previous occasions where they would fight, yet they would still continue to have sexual intercourse.
Also, I have another question with regards to this issue of evidence being compromised. According to the judgment, it came out in evidence that they had discussed the case after the bail. So, isn't that interference that could have led to the compromising of the evidence by the complainant?
Respectfully, Your Ladyship, we disagree. Based on the evidence produced before the court and the opinions, the judgment of the learned judge, there was a judgment delivered, and he made findings based on the evidence that was before him. And based on the evidence before him, there was no evidence suggesting that our client had in fact compromised with the evidence of the complainant.
But according to the copy record, counsel, part of his bail condition was not to interfere with any of the prosecution witnesses. Don't you think they're discussing the case with the complainant, taking into account all the domestic violence situations that she was subjected to? Wouldn't that amount to interference on his part, thereby leading to the evidence by the complainant, even if I will be compromised?
I'm sorry, Your Ladyship, would you be able to repeat that question?
Part of his bail condition, this is according to the copy records, part of his bail condition was not to interfere with any of the prosecution witnesses. Now, after he was being granted bail, this came out in evidence that they had discussed the case. He discussed the case with the complainant. That was not allowed by the bail condition. Now, from the evidence again, since they have discussed it, he discussed with the complainant, isn't that interference with the complainant? And leading on from that to the compromising of her evidence given at trial.
Your Ladyship, we
Together with the domestic violence that was going on.
Your Ladyship, we again maintain that there was no interference because our client was not aware. And if we refer to paragraph 17,
Sorry, counsel, your client was not aware of what? Of the bail condition, not to interfere.
he was not aware that he was in fact frightening her or that in hindsight that he was intimidating her. And if we refer to paragraph 17, it was actually the complainant that had resumed cohabitation with the accused.
But don't you agree that he ought not to have resumed cohabitation or even discuss the case with the complainant?
My issue, we would like to draw the court's attention that this is a marital case, and in the ordinary course of marital discussions, this would be something that they would naturally discuss.
The case at hand, the case in which the client was being interfered.
The discussion that we are referring to is the discussion that she was uncomfortable and she was not consenting, and all the other situations where she might have been subject to things that she did not like, that was disclosed in the discussion to the accused. And following that discussion, the accused then ceased his actions.
he sees these actions of domestic violence, the physical assault. It was not sexual intercourse or the rape.
Yes, Your Ladyship. We cannot pinpoint a precise predict what will happen in the future, but from the facts we can ascertain that he had ceased his domestic violence tendencies. I'm sorry, my lady, could you just elaborate on what you were asking for?
No, Counsel, you had mentioned that he had ceased his actions. You are referring to his actions in terms of domestic violence and physical assaults. Not the sexual intercourse. That never came out in evidence. According to the judgment and the evidence that was produced, according to the court record, it was actually his actions towards physical assault that ceased after he came out from remand.
But Your Ladyship, we can see that once he was informed of his actions, once that he was made aware of the consequences and the implications of his actions, he ceased. So it is only a reasonable inference that we can make that he would do the same thing with regards to consent once he was made aware. However, we cannot specify or predict the future. We can only discuss at hand, rather than the domestic violence issue, whether or not there was consent. And at the court of first instance, in the regards of consent, the trial judge held that it was not proven beyond reasonable doubt. And that is a argument that we will be making throughout our submissions, that in regards to beyond reasonable doubt, specifically to the issue of consent.
But Counsel, the point that the appellants had been making was with regards to the interference by the accused, by your client, the respondent. After he was released from remand, he was given bail. And according to the evidence that was highlighted in the judgment, there were discussions about the case after he was released from bail. So what the appellants are submitting is that because of the discussion of the case, because of domestic violence happening in the background, where she was being subjected to all this domestic violence and physical assault, it has gotten her to a point where she was actually frightened. So with that in mind, the case we discussed with the complainant, they are arguing that there was actually interference and that the evidence that was used during trial was actually it was compromised.
Again, my lady, we maintain that there was no interference, and we refer to section 16, section 17, and section 19, that she never expressly refused sexual intercourse, that it was her that resumed cohabitation with the accused, and that she had never pushed the accused away.
Yes, Counsel, this was the evidence you're referring to, the evidence that came out in trial. The balance of mission is that that particular evidence only came out because of the interference by the person.
Respectfully, your ladyship, we disagree. If my ladyship have another question, counsel would like to proceed with submission. My lady, in omitting submission 3.7, we now move on to submission 3.8. The counsel for the respondents respectfully submit that this was the basis for the learned judge's findings. If the complainant had said no to the accused and she did not struggle, then how was the accused supposed to know about there being no consent? Which was supported by the facts and was a finding that he could safely reach based on the evidence presented in court. This was because by paragraph 13, as previously mentioned, he and the complainant would occasionally fight, albeit not talking to each other. They would continue to live as husband and wife, which meant including sexual intercourse. Because of the normality and the arrangement between the couple, the concerns of the complainant were not made known to him until after the complainant went to a feminist counseling session, and she spoke with him about the issue after the accused was failed. Upon this being pointed out to the accused, the complainant and the accused reconciled and have since rectified the situation. Thus, we submit that the judge did not err in law or in fact when he acquitted the respondent.
Also, this report solved rape of the allegation. Did it come before or after the family counseling session?
Maybe I have a moment to just gather that. It came as a result of the allegation. So as the allegation was brought to light, it was then when, on that specific allegation, that the police then took her to the guidance counseling session.
So it was not after the feminist counseling session that the allegations arose, right?
No, it was as a result of the allegations.
So wouldn't it be if to argue that it was after the counseling session that these allegations how you reference
My lady, with respect to the counseling sessions, we are maintaining that it was through that counseling sessions that both parties actually became aware of what was actually transpiring between them. And that would, of course, not have come to light without the fifth allegation, the incident of reported domestic violence where the race allegations came out. My ladyships. To further illustrate this, we invite the court's attention to the case of State against Ismail in the year 2014, as reported in the High Court Criminal Case Action number 115 of 2012. Your ladyships, you may find this in tab 1 of the bundle of authorities. Before I proceed, would your ladyships care for a summary of the facts? Your ladyships, in this case, the accused and the complainant had been separated for 4 years, but still remained legally married. On the incident in question, the accused had gone to the complainant's house and had taken her to the kitchen to talk about the divorce that the accused had been contemplating. Following the complainant's refusal for a divorce, the accused then forced himself upon her and proceeded with sexual intercourse, despite the complainant's refusal. Your ladyships, in this case it was held that if a wife is compelled to have sexual intercourse against her will by the use of authority, force, or by threat of using force, she has the right to say no, to use such sexual demands of her husband. If the husband decides to proceed ahead despite of that no, he risks being criminally liable for raping his own wife. Your ladyships, it is our submission this is distinguishable from the present case at hand, because as stated earlier, the complainant had not by her gestures or words indicated that she was uncomfortable. Therefore, it is our submission that there was no way for the accused to know the implications of his actions, since the nature and the regularity of the act within the consortium of marriage made it reasonable for our client to infer that it was consensual.
I have a question on statement is my lord. So in reading this quote, we take into account the entire context. Justice Bandara had said this because he was reiterating that the marital exception to rape no longer exists federally. And so then that's why he said that the wife now has a right to say no. Is it your submission that there literally has to be a verbal no from the wife?
There has to be a verbal no from the wife, in addition to some form of expression that she was not consenting. Because the harsh reality is that how would the accused ever have known that she was uncomfortable unless it was expressed by the complainant? Because the reality is that the accused would not have known, and he would continue to act on it based on previous incidents.
Was the defendant required to take steps to determine or if she was consenting?
Certainly, Your Ladyship, but at this point in time, at the incident in question, he was not aware. It was only after the feminist counseling session that both parties became more informed.
So, was it that he just didn't care whether she was consenting at all or not?
Certainly not, Your Ladyship. He took that that inferable consent based on previous occasions. That even that after their fights, they would continue having sexual intercourse.
These are the same fights which led to physical violence against the wife.
Yes, Your Ladyship.
So, going along the same reasons, would you not say that according to Section 206, there has been no consent here because there's an element of fear and intimidation in this instances of intercourse?
Again, Your Ladyship, we maintain that even if there was fear and intimidation, it was not made, our client was not aware of it.
But in State and Ishmael, there was no history of domestic violence, was there?
No regulation.
And so that distinguishes it from the present case, from this appeal.
Certainly, Your Ladyship.
Because in State and Ishmael, the use of force was only before he committed the offense of rape on his lawful wife. And here in this case, there's been a period of domestic violence.
Yes, Your Ladyship. If we may refer to paragraph 25 of this file, it was stated that what matters was whether consent was given, not the relationship between the perpetrator, not the relationship that the perpetrator shares with the victim. For the purposes of that specific analogy, we would like to maintain that the issue that we are trying to parallel with Ismail is the issue of consent. And in Ismail, she
So,
had...
but in Ishmael, the complainant had struggled, and she was tackled to the ground when she was 6 months pregnant, and the infringers committed on her. In this case, so she wasn't exposed to a period of domestic violence, and the appellants have stated that they cited the case of Regina and Alwadia to say that those who are going through abuse, victims of abuse, never react. And we don't find the relevance of this file to this appeal because in your argument you're saying that she should have at least shown by her actions or by her conduct that she wasn't consenting. The difference is that in this case there's a period of domestic violence, and the appellant is saying that because of that she was submitted into consent, even though she didn't actually agree to the act of sexual intercourse with the respondent.
Yes, Your Ladyship, with due respect, we do not seek to analogize the facts of Ismail to the present case. We merely seek to use the statement that was made by Justice Angara. And ultimately, the husband would continue living in that honest and reasonable belief that she was consenting. And it would have been a different matter, as stated in Ismail, if she had expressed her discontent.
You mentioned honest and reasonable belief. Is that the law in Fiji that there should be honest and reasonable belief as to the giving of consent, or consent must be freely and voluntarily given?
Your Ladyship, it is a defense made available for someone who had on previous occasions had received consent, and that is available at section 30, subsection 5 of the Crimes Act, which my learned colleague will subsequently elaborate on.
And that is contradictory to the law of couples that already exists in that consent is on an ongoing basis. You can't just assume consent because you gave it once before, it doesn't roll over.
Respectfully, my Ladyship, we still again maintain our argument that our client had made this decision based on previous occasions, and because of the arrangement and the normality of it between them as a couple, that it was considered as normal. If my Ladyships have no further questions, that is all the respondent has to submit on grounds 1, 2, and 3 of the appeals, and my learned colleague will make the remaining submission on grounds.
My ladies, may it please the Honorable Court, I will be making the remaining submissions on behalf of the respondents. And that is that the learned judge had not erred in acquitting the accused by finding that the prosecution had not proven beyond reasonable doubt the issue of lack of consent as consent could be said to have been reasonably inferred or reasonably and honestly believed. My ladies, in moving on to submission 4.1.1 in our memorandum of argument that is before you, at the outset, my ladies, it was determined by the learned judge in the court of first instance that not all the elements of the offense of rape were satisfied in this case. Therefore, my ladies, I would like to invite the court's attention to section 207, subsection 1 and subsection 2, part A of the Crimes Act. And you may find that in our bundle of authorities at tab C, page 74. My ladies, this provision stipulates that any person who rapes another commits an indictable offense, penalty for which is imprisonment for life. A person rapes another person if that person has carnal knowledge with or of the other person without the other person's consent. My ladies, the counsel for the respondents submit that as determined by the court of first instance, the High Court, that the element of without the other person's consent was not proved beyond reasonable doubt. This being submitted, my ladies, we will highlight that our client had reasonable grounds to believe that the sexual intercourse was consensual. In his judgment, the learned trial judge stated in paragraph 11 that consideration must be given to whether, and I quote, such a belief of the accused was reasonable under the circumstances prevailing at the time of the alleged incident. My learned colleague had submitted earlier regarding this, and I shall delve into this a little further, your ladyship. My ladies, I would now like to invite the court's attention to section 30, subsection 5 of the Crimes Act, again, tab C in our bundle of authorities before you, on page 74. This provision, my ladies, states that a person may be regarded as having considered whether or not the facts existed if he or she had considered on a previous occasion whether those facts existed in circumstances surrounding that occasion, and he or she honestly and reasonably believed that the circumstances surrounding the present occasion were the same or substantially the same as those surrounding the previous occasion. My ladies, our client and the complainant are in a mutual de facto relationship where sexual relations, we submit that in such relationships, sexual relations or sexual intercourse may be considered to be a natural aspect of such a relationship. As stated in the facts and evidence in the judgment, in the court of first instance, and to reiterate my learned colleague's earlier submission, there has never been a time when the complainant had positively refused to have sexual relations with our client. We further submit, my ladies, that having sexual relations without refusal was a normal part of our client and the complainant's relationship, and they have never had any problems relating to such. We therefore submit, my ladies, that at the time of the incidents in question, it seemed to just be another one of those times that they would have sexual relations in the usual manner, as you would do in a de facto relationship. And our client was of the understanding that this was consensual. My ladies, I do apologize for that. My ladies, in addressing the fact that the complainant's failure to express refusal and its impact on the belief of our client, I invite the court's attention to the United Kingdom case of Director of Public Prosecutions against Morgan in 1976 in the House of Lords, Appeal Action 182. My ladies, I refer to tab B in the bundle of authorities.
This council, please also reflect on it, please.
Certainly, my ladies. In this case, the defendant Morgan had invited the three other defendants to have sexual intercourse with his wife. He told them that if she struggled, this was not to be considered as a lack of consent or refusal, as she enjoyed such acts and kinky methods. It turned out that all this was done without the wife's consent. The defendants were convicted and they appealed to the House of Lords on the grounds that the trial judge erred in, the trial judge erred in law by directing the jury that the defendants believed in consent, and I'm referring to the defense that the defendants had raised. The trial judge directed the jury to ascertain that the defendants' belief in consent had to be reasonable in order to constitute a valid defense for rape. The House of Lords, however, held that as a defense to rape, the belief only had to be genuine and honest and not reasonable. However, the convictions were upheld as the House of Lords also found that even upon such direction being given to the jury, no reasonable jury would have found them not guilty. My ladies, we do not wish to analogize the facts of this case as it is quite different to the one at hand. However, my ladies, we do draw on the principle of honest consent. And we bring up this case because Fiji's statutory provisions of honest belief, my apologies. And we bring up this case because Fiji's statutory provisions, as I mentioned earlier in section 30, subsection 5, has gone on to extend honest belief to be both reasonable and honest. In submitting this, my ladies, and considering the history of the sexual relations of our client and the complainant, there had never been communicated to our client by the complainant a lack of consent or refusal, thus leading our client to the belief that she had never refused to have sexual intercourse with him. A lady has submitted earlier. This belief was also founded based on our client's understanding of the ambience of their relationship, of their de facto relationship, and what constituted usual conduct as husband and wife. Therefore, my ladies, we submit that the belief in consent by our client was both reasonable and honest. My ladies, moving on to submission 4.2.2, my learned colleague had made reference to the case of State against Ismail. However, as submitted, we do not wish to analogize the facts of this case, but give consideration to the statements regarding consent and refusal by the learned Justice Bandera. In distinguishing the case at hand from the case of Ismail, of State against Ismail, there was no refusal made known to our client by the complainant. And as earlier submitted, my ladies, we further advance the argument that he held a reasonable and honest belief that their sexual intercourse was consensual.
Even though we have a soft consent.
My ladies, we further submit that consent is also about saying no and making, and about the complainant making this known to our client. As as seen in the judgment, in the evidence of this case, our client was of the belief and even considered that despite the fights and despite all that they went through, they would still carry on as husband and wife. And to the best of his knowledge, my ladies, this also meant having sexual intercourse. And that this sexual intercourse was consensual, based on the reasonable and honest belief that he held.
And you would be of the opinion that, given the history of domestic violence, any reasonable person would still go on in the sexual intercourse with the belief that there was full consent given.
My ladies, respectfully, we advance our client's understanding that despite the fights that they had, he was able to draw a line from this and their functions as husband and wife. Though they did not speak to each other, they continued living with each other, and this meant also having sexual intercourse, being consensual. And that is what we submit on behalf of our client, my ladies.
Counsel, you referred to the case of DPP against Morgan on the reasonable belief as consent. Is Morgan still a good law instrument in the UK? Do you know?
My lady, I understand that is not, and that is why counsels for the respondents have also drawn on the statutory provisions of the law in Fiji that has gone on to further extend the principle in DPP against Morgan, that while Morgan says belief or consent only had to be honest, the law in Fiji has further gone on to say that it has to be honest and reasonable. And that is what we submit on behalf of our client relationships. My ladies, furthermore, and we further advance that our client had no reason to believe that there was refusal on the part of the complainant.
So you see the judgment in paragraph 16. And the complainant was being cross-examined. She agreed that she never expressly refused the accused sexual intercourse. But she also agreed that he never asked her before he had sexual intercourse. So you see, though there is reasonable belief, you're talking about the submission of the fourth element, but we also have to consider about whether she was being asked that, because that came out in evidence. The complainant also stated during her evidence that she did not like the fact that he would just come and have sexual intercourse with her without asking her for her consent. So how is the complainant? How would you advance your argument on the fact that the complainant never gave her consent, but in the first place she was never asked for her consent?
My ladies, based on the reasonable and honest beliefs of our client and the nature and history of their relationship, how was he ever to know that she did not consent? And as submitted by my learned colleague, and also as seen in the evidence of the judgment, that their understanding of their relationship changed after the feminist counseling session and as this trial proceeded, my ladies. And that is where we submit that up until then, our client was of the reasonable and honest belief that the sexual relations with his wife was consensual based on the ambience of their de facto relationship.
So basically your argument is that it is perfectly all right for a husband to have sex with his wife without even asking for her consent.
My ladies,
This is based on the reasonable and honest belief of our client and even the history of their living together and being in a de facto relationship for 2 years, and to their understanding of husband and of carrying on usually as husband and wife, was participating in sexual intercourse in the usual manner that they did, and that was consensual. However, my lady, as submitted by my learned colleague earlier, after this matter was reported to police and the family's counseling, and after the family's counseling session and these proceedings in court, there was a change in the nature of their relationship as they gained more understanding about what was before them and even the problems they had with them. And the complainant was even able to raise these concerns that she had about not being asked and about consent to sexual intercourse, my ladies.
So, counsel, the reasonable belief, was it based on previous sexual history or because of the fact that they were husband and wife?
My ladies, it is based on their sexual history and both of the ambience of their relationship as husband and wife, as seen in the judgment that our client's understanding of being husband and wife, despite all that they went through, was still about having sexual intercourse with each other.
Counsel, one of the grounds of appeal is that the consideration is based on gender stereotypes, which the appellant has raised is not a legal consideration. But no one has cared to inform this court or enlighten this court on what is a gender stereotype.
Ladies, as earlier advanced and submitted by our clients, by my learned colleague, we maintain that in the judgment, and as I believe the section that your ladyships are referring to, section 20, as paragraph 20, was the judge's assessment of the evidence laid before him.
But the court's question is anyone from the respondents side wish to enlighten the court on what is a gender stereotype? It has been raised as a ground of appeal before the court.
Lady, is that question just being being addressed to me or our team of solicitors on the respondent side?
To the respondents.
Lady, if I may seek further assistance from my learned colleague who had submitted on this ground of appeal earlier to enlighten the court and perhaps answer your ladyship's question.
Your Ladyship, the specific reference to what is a gender stereotype is clearly illustrated in what the complainant had actually indicated was her opinion that what of a good wife. And that is an example of a gender stereotype that we can take. However, we are still maintaining our argument that gender stereotypes did not compromise the evidence because the learned judge had made his findings based on the evidence that was adduced before him.
Counsel, just final question on the it is current law in Fiji that gender stereotypes is not a legal consideration, and that if a woman or a man doesn't cry or look distressed, a stereotype would be if a woman or a man doesn't cry or look distressed or complain immediately after the incident, then they were not raped. The court had certainly considered that when it came to its decision to acquit the accused, that she had the opportunity to inform her sister of what she was going through, but she did not take that opportunity. And what would you submit with regards to that?
My ladies, again, is further advanced and submitted earlier by my learned colleague, that we maintain that it is a assessment of the evidence before the learned trial judge. And furthermore, your ladyships, we again maintain and advance that after the feminist counseling session, things changed in the relationship between our clients and the domestic violence and gender stereotypes that your ladyships have in question. My ladies, furthermore, and in concluding the submission on this fourth ground of appeal, our client has only ever acted on his reasonable and honest belief, and as found by the learned judge in the court of first instance, in paragraph 2 of the judgment, we further submit that this honest and reasonable belief on the part of our client has created a reasonable doubt as to the satisfaction of the consent elements of the offense in question. My ladies, if there are no further questions on this aspect of the submission, the counsel for the respondents would now like to proceed to our conclusion and prayers. To sum up, my lady, the senior counsel, my learned colleague, has submitted that the learned judge had not erred in law and fact, as it was not evident that the complainant's evidence was compromised by interference from the accused. Secondly, that the learned trial judge had not erred by not considering the background of domestic violence the complainant was being subjected to, and its bearing on her evidence in court in regards to the issue of consent. And thirdly, my learned colleague has submitted that the learned trial judge in the court of first instance had not erred in his judgment when he used various gender stereotypes as the basis of his findings as to the complainant's consent. And my ladies, I have submitted that the learned trial judge had not erred in acquitting the accused by finding that prosecution had not proved beyond reasonable doubt the issue of lack of consent, as consent would be said to have been reasonably inferred or reasonably and honestly believed by our client. Furthermore, my ladies, counsel for the respondents pray that the acquittal be upheld and that the learned trial judge did not err in law nor fact, and this appeal be dismissed with costs. This is all I have to submit, your ladyships. May I assist the court with anything further? Much obliged, your ladyships.
For the appellant, you have 7 minutes to your law. Yes, this honorable court, please. First, I would like to correct the senior counsel for the respondents that this proceeding is not a marital case, but an appeal to a marital trade case. May I refer this honorable court to the respondent's submission under 3.4, that the learned judge had not erred in his judgment when he used various gender stereotypes as the basis of his finding as to the complainant's consent, thereby denying the complainant due process and access to justice. With reference to paragraph 20 of the judgment, the learned judge had erred when he mentioned that the complainant was a woman who was being a good wife by submitting to her husband. May I refer this honorable court to the respondent's submission under 3.5. The question that this court needs to ask itself is, if an accused is released on bail and then decides with the complainant, would this court believe that there is no coercion made to the complainant? Perhaps not your initials. The respondent has been charged with a serious offense, and it is obvious that he will try everything in his capacity to be freed from the charge against you. When you look at the particulars of the offense, this incident occurred between 31st December 2019 and January 2020. Supposedly, the respondent was charged sometime in February, and also he was released on the same day. And when, if you calculate the number of months the respondent has been residing with the complainant, it comes to a total of more than 4 months. Therefore, the appellant hereby submits that the respondent had sufficient opportunity to influence or coerce the complainant. May I refer this honorable court to the respondent's submission under 3.6. It is evident that there was a domestic violence restraining order in place. So how can the respondent say that the complainant did not identify herself as a victim? The fact that the domestic violence restraining order was in place shows that the complainant was a victim. May I refer this honorable court to the respondent's submission under 3.9 and 4.2.2. The case of State versus Ismail is a High Court matter. And any decisions from the High Court jurisdiction is not binding in this court. May I now refer this honorable court to the respondent's submission under 3.1. How can the respondent say that there was no way for the accused to know the implications of his actions, and that given their de facto relationship, you inferred it was consensual? With reference to what has already been alluded by our co-counsels, the case of R versus R has set a precedent that there was no marital rape exception. Rape is rape. May I now refer this honorable court to the respondent's submission under 4.2. The respondents have quoted a provision from a legislation, but have not mentioned the legislation. The most relevant and most applicable section in this matter is section 206 of the Crimes Act 209, which my co-counsels have already alluded. And we still maintain our ground on the issue of consent. Therefore, the ladieships, in light of the discussions alluded above, we the appellants pray that this honorable court considers our application.
begin with, as our learned friends had earlier on stated, and court had pointed out, the R&R case was irrelevant because it did not have any provocation elements at the facts at hand. The charges were totally different, hence irrelevant once again. Moving on, paragraph 16 of the judgment, if I may direct the court's attention. During her cross-examination by the defense counsel, she agreed that she never expressly refused the accused sexual intercourse, but maintains that he never asked her for sex. She also agrees during cross-examination that these rape allegations were all her fault. She agreed that she has a sister who lives next door to her and that she had not disclosed the incidents to her sister, whom she was very close to. It was also put to her that she had only raised the complaints about rape when the police had asked her about the domestic violence complaint, which takes us to the DVRO point that was pointed out by our learned friends, that the DVRO came after the fifth allegation, as seen in paragraph 15, because the complainant did not want the accused, that is our client, to be charged multiple times as they were reported to the police. She only went there once to the feminist counseling, as we have referred to it before, and she did return for counseling because she talked with the accused and everything was alright again between them. With regards to State and Ismail case, we bring this case in front of the court as a persuasive film, and in paragraph 24 and 25 in tab A, the husband and wife relationship comes in reference to sentencing and not in for the conviction of the accused. The relationship, therefore, does not have any bearing on whether the rape happened or not. Furthermore, your ladyship, our client is not a mind reader. According to our client, the complainant was consenting as she never pushed, cried, or said a clear no. So there is no way our client would have known. This is also enlightened in paragraph 19 of the judgment. Moving on, your ladyships, we do not believe that as a husband, the husband should not ask for consent from his wife just because he is married to her or they are in a de facto relationship. But as a case, the issue at hand, what we are referring to is that our client was not aware because, though, as pointed out by our learned friends, they were in a relationship for more than 12 months. There was still not even a slight implication that the complainant was refusing for any physical sexual intercourse. That's all, your leadership. Much obliged.
Relationships, we may add to another. No counsel. You think given a chance to invite, so just end it here. But this court is waiting for your submission. And the case authorities have been given by both counsels. And the court will take everything into consideration and we shall now adjourn for judgment. And it will now be adjourned for judgment on the 9th of April. 9th of April. All right.
We start with the
the feedback, just make sure we enjoyed listening to the arguments and the submissions that have been made. But just to make sure that you read your cases and be able to compare and contrast and distinguish the cases. And also just stick to the basics, the things that usually we forget the basics, but they are the most important things. For example, if there's an appeal and we ask if the parties can enlighten us on what is a gender stereotype, but no one had that definition for the court, and no one also had, for example, what is domestic violence, and referred us to the Domestic Violence Act. But it also ensure our attitude to the court, answering the court's questions, and don't, when the court is asking a question, then we go over and just continue with our submissions. It's very good, especially in court. If you don't know the answer, then just say so, and the court will understand. And probably the other party will have the answer, and then you can have a chance to also give a submission on that issue. And ensure you link up your arguments. So just to guide the court and say, well, following on from that, this, and then link it all up to come down to what you want the court to do in favor of your case. So you just make the court in that way. Also, I think with time, we will learn to be able to articulate and we learn thinking on our feet. Thank you.
Yes, so I think for both of the schools, considering that you year one, you get, I think you pretty well based on your arguments and your presentation. I think what you just need to know is that you really need to understand your laws. For example, when we were asking about the domestic violence, the restraining orders that were given, right? Section 27 Eastern Constitution, there was some confusion that indicated that there was a non-contact order. So when you are making your arguments for the court of appeal, for each court, you have to know your laws. You have to understand how to argue your laws. Probably also you need to know your cases, the cases that you're referring to in your submissions. So you need to understand what case is relevant to your argument, what will advance your argument, and what will definitely not help you. Also, with your own case that you are appealing, you must know your facts. You should never ever use the words "you might have" when you are submitting to the court. Don't ever use words that would indicate to the court that you're even unsure of your own case that you are arguing. You also, when you've been asked the question as well, you don't tell the bench that you're going to answer it later on. While you were submitting, right? So you need to answer the question and address it at that point in the part. And also use the law when it's on your side. For example, for the appellant, you had section 206 that was in your favor in terms of the definition of consent. You just need to know how to use the law together with the facts to lead your arguments. And don't ever show the court that the questions are starting to burden you, that you're starting to get confused with the questions. Because there were moments when questions were being asked, counsels were either closing their eyes and thinking or breathing heavily. And so when you are appearing in court, you are actually the closest thing to the bench so they can see they can see how you react. Yeah, and also know what your orders are, the orders that you're seeking for their balance. You have to understand and know what you're actually arguing for. Are you arguing for a conviction, or are you arguing for a retrial? Those type of things. For the respondents, your submissions were actually pretty clear and very concise, which is a good. And you really thought about your arguments before you actually open your mouth to speak. So that was very good. But don't ever cut the bench off when they're asking you questions. And you also need to know your facts very well. In terms of case authority, you need to submit that earlier on. Give the court a chance to actually read through the submissions and read through your case authority. And also pay attention to the questions by the bench. Because if you've already canvassed a certain point that you want to make in a submission, that the court was asking you a question, you don't have to go and repeat it again as another submission, as part of your submission later on. It's already covered. Because sometimes the court gets very bored, listen to counsels go on and start talking. So, yeah, and don't ever use a lower court's case in a appellate court. Don't ever do that, because I understand that there is a issue that a high court case. In a real court of appeal, we would have it to look for that. So, yeah.
Yeah, voting is great, but it's not an easy task, so I think the teams for participating. I'm just going to echo the sentiments of Mr. Sua and Mr. Rai. And I agree with everything that said. One thing that stood out to me was the use of the case law in the submissions. If you're seeking to rely on them, and if you're quoting something out of context, just make sure that you have the arguments where the court does the entirety of the context into question. And if you're relying on a case that is so totally different from the matter at hand, just be sure that it's concise and that it can get across to the reason and ambiguity in between. Another thing I noticed was the reference to foreign cases, especially R&R. I had looked that up on your site earlier, and there are references to that in 15 cases. So when you are in court, it's good to rely on English cases, and you can propose the jurisprudence from there. But always make sure that we have applied it locally. And always make sure that if the court asks you, there's a local case that applies it, and that not was going to be binding. And with that being said, I don't have